Do opening arguments have to be stuffy and formal? Or can they be an informal conversation with the jury as if we're having a nice, pleasant conversation? Would you like to learn the answer? Come join me for a moment as we walk on the beach and I tell you exactly the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no. Opening arguments do not have to be stuffy and formal. They can be a pleasant conversation with the jury even though it is a one-sided conversation. So what do I mean? There are many attorneys who are very stiff and formal, but even so, even though you'll find some attorneys who are very stiff and formal and the judge is very formal, you will find that some of the best trial lawyers in New York are ones who turn around and have a great conversation with the jury about the facts of this case, about what the doctor did wrong to cause this patient harm and injury. That's the whole idea. You're telling the jury a story to explain to them about the violations from the basic standards of medical care so that they understand exactly why we're here, exactly what we're seeking to accomplish, and the proof that they're going to hear, the testimony, the evidence that they're going to hear that will validate and go ahead and support our particular claim for a verdict in our favor. So now, if you go into court to watch a trial, if you are there for opening arguments, you will notice something very interesting. After the judge has given the jury some basic preliminary instructions on what to do and what to expect, now he'll turn to the plaintiff's attorney, the attorney who represents the patient. For example, he'll say, Mr. Oginski, you may begin your opening arguments. You will notice that the attorney, no matter how casual, no matter how comfortable, no matter how informal he's trying to be, is still going to thank the judge and at the very beginning, be a little bit formal. May it please the court. Ladies and gentlemen of the jury, let me tell you what happened to Sally. Okay? Why do we do that? Because there are still formalities to be adhered to. There's still respect to be given to the court, to the judge, that we have to do that. It's a rare attorney who turns around, does not acknowledge the judge, does not give the court the proper respect, and does not give the jury the proper respect. So there are small formalities that are customary to give when an attorney begins his opening argument. Does that mean that an attorney who doesn't acknowledge the judge or acknowledge the jury, that something is wrong? No, it means that they're trying to be a little bit different, trying to be creative, but customarily, through hundreds of years of practice, hundreds of years of custom, it's developed that attorneys respect the court. May it please the court. And that was done in hundreds of years ago when an attorney would present his client's case to the court, and typically they would bow down or wear robes and wear wigs like they do in the UK, but that's not done in the United States. In the United States, we don't have that type of formality, but still we do acknowledge the judge, and it's critical to do so because the jury looks at us to see that we're being respectful to the court, because the jury looks to the judge for approval for everything. The judge controls everything that happens in the courtroom, from what law to give, to what can and cannot be introduced into evidence, to what witnesses can and cannot testify. They look to the judge to see what time they can take a break and when they have to leave and other various legal instructions that occur. So if an attorney right off the bat at the beginning of the case is not respectful to the court or being disrespectful, which is even worse, now the jury questions themselves and say, why is this guy being such a jerk? Why isn't he acknowledging the judge? The judge is responsible for everything that happens in the courtroom. So the key is, yes, we have to acknowledge and be respectful of the court and the various little customs that actually occur in these civil lawsuits. But now, once we've done that, once we've acknowledged the court, may it please the court, ladies and gentlemen, in this case you're going to hear about Sally, who is 23 years old, who complained of a breast lump when she went to her gynecologist. We're going to show you, the evidence is going to show that the doctor that she went to violated the basic standards of medical care, causing her significant harm and injury. And let me tell you how she actually did that. And now I'm going to go ahead and detail for the jury for the very first time exactly what our claims are and why we believe the doctor was careless and caused my client all this harm and injury. So can I do that in a conversational setting like we are right now? I'm not talking about wearing a t-shirt. I'm talking about having a nice, pleasant conversation so the jury understands. And many times attorneys think, oh, I have to stand at the podium in order to talk to the jury. No, if you're having a conversation with somebody, you don't stand behind a lectern. You don't stand with something impeding between you and the person you're talking to. Instead, you're talking to them face to face. You're having a human conversation. And if you can do that, if you can explain to the jury in a normal conversation, then they can relate to you in a much better sense than if you were all stuffy and formal, standing behind a lectern reading from your notes. Now, that doesn't mean that can't be effective, but from a perspective of the jury understanding and bonding with you, I think personally that you have a much better chance of connecting with the jury in a nice, casual, informal conversation that they can truly understand. So why do I share this quick video with you? I share it with you just to give you some information about how these types of cases work in New York. And I recognize that you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you're thinking about bringing a lawsuit, but have not done so yet because you still have questions that need to be answered, then what I invite you to do is pick up the phone and call me. We'll chat on the beach. No, we don't have to chat on the beach. We can chat on the phone. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.